Well, especially if you're in a hurry, right? You
Yeah.
can see something.
Right, yeah, you can start with farmland, it's just wonderful.
I go to general staff. And I do, I go to a bunch of other places, just the waste and the stupidity and yeah, I think certain things are bad and local governments should see the waste is just, we can do the same project commercially, 65 cents on the dollar, and we can, yeah, so much cheap, well, a lot of them, they allow work from there a couple of years down there. And here's my roommate, because I was over there. He's the condo area is 3 miles from work, taking 15, 20 minutes on that. And then they all the crews there work at 5 in the morning, so then they go out before the rush hour, come home after, before the morning rush hour, before the, so all the contractors work early.
Yeah, pull my traffic.
That's the only way you can do it.
Yeah, well, that's what when we left, we were down by Reedville. How do you want to leave? She said, about 4:30. And she's like, and the boys are like, no. I'm like, well, 5:30 is the latest. And we went through there at 7:30, and it wasn't hard on the highway, we went through Washington.
Brian, I think we're all here.
Okay, we can get started. Thanks for having me over, seeing everybody again. By show of hands, so I get an idea, how many members of people here are on the Planning Commission? And the ZBA? We have no members from the ZBA? Just, okay, you have a couple, okay. So you're up on both? Okay. What I wanted to do is kind of go over some issues that you have kind of a seminar, so you not only know what your responsibilities and roles are under the zoning laws, but also what everybody else does. It's kind of nice to know how you fit together in the cog, so you know what other people's responsibilities are when you're dealing with zoning issues. I think that when you're dealing with local government, zoning decisions are probably one of the most difficult decisions that local government has to make. You're in a small community, you know people, and they're going to be coming before you for variances or special use permits. And the tendency is that you want to help them, okay? Because that's general human nature. That can get you into trouble, okay? Because that's not the role of zoning decisions. Zoning decisions are not based on popularity. It's not based on whether you like someone or you like their proposed development or whether you don't. Zoning decisions are based on the requirements of the zoning ordinance. You have to make the decisions based on the zoning ordinance, not how you personally feel or how the community may feel, okay? When you're dealing with zoning, you're dealing with property rights. People have a right to use their land, but when you have zoning, you're in essence telling them how they're going to be able to use their property in some circumstances for the benefit of the community as a whole. So in essence, you have to balance those interests, and sometimes when you do that, you are in fact required to use the requirements of the zoning ordinance. When you make zoning decisions like variances or special use permits, they're discretionary in nature. They're administrative discretionary decisions. And when you make those kinds of decisions, courts will strike those decisions down if it's based on what they call unfettered discretion, okay? So to avoid that, you have to make your decisions based on the standards of the zoning ordinance, the approval standards. There's lots of discretionary decisions. When I go through various things, I want to point out those portions of your zoning ordinance that have those approval standards. And so that's a way to do that, okay? It's always important for the village officials, the property owners, people that represent the property owners, and the general public it's helpful for them to know what the discretionary approval standards are, so they can present information to you at your public hearings that are relevant to your decision-making process. You would not believe how many times I have attended a variance hearing on a ZBA, and people may want a side yard setback variance. And they stand up and say, we're gonna build this garage, it's gonna be painted blue, it's gonna have nice black shingles, it's gonna be really nice for us, and so please give me my variance, okay? People in the opposition, the public, they say, well, this is a terrible idea, it's too close to my house, I don't like the color blue, okay, it should have red shingles and not black shingles, and therefore please deny the variance, okay? That has nothing to do with zoning, okay? The approval standards for a variance. I've often advised that when you have various applications, okay, variance application, a special use permit application, a planned unit development, or a site plan, that you have this approval standards and you turn them into questions, okay, which then forces the individual to answer the questions that directly relate to the approval standards that you must apply in order to make the decision, okay? Otherwise, you're going to get it's going to be a pink polka dotted house or a blue garage with black shingles, which isn't giving you any information that you can then use to properly base your decision, okay? Like I say, you can't stand up and say it's a good idea or a bad idea. You've got to base it on the standards, okay? The process then requires that you hold a public hearing, okay? You receive the evidence. Everybody knows what a trial is, okay? You have a murder trial, and what do you have at a murder trial? You have witnesses testifying, you have exhibits that are introduced as to evidence, and then it's all done in front of a jury. The jury then ultimately goes into the jury room and deliberates and decides whether the person is guilty or not guilty or whatever crime's been charged. That's a very similar process to what zoning officials go through, okay? You're at a public hearing, okay? At this public hearing, you gather and receive evidence, okay? What's evidence? Evidence can be statements made by the applicant, can be statements made by the public, even though they're not sworn as witnesses, they're providing you information. They're providing you documents that you're going to then rely on to make your decision. You identify those documents, Exhibit 1, Exhibit 2, Exhibit 3. The first exhibit on every zoning decision, very simple, it's the zoning ordinance. Zoning ordinance is a document. It's something that you're relying on to make your decision. The application for the variance for the special use permit is a document. That's going to be an exhibit. The site plan, the drawing as to what they want to do on their land, that's an exhibit, okay? There could be photographs, okay? They may want to show you various attributes of their property. Remember, if someone doesn't like a decision, what do? They appeal that. And where does that go? It goes to a court. Judges here in the Antrim County reside in Traverse City. They've never seen this land, okay? If it goes on appeal, it goes to three judges in Lansing or Grand Rapids. They've never been to the property. They have no idea what it's like. Photographs are probably a good idea because you're documenting for evidentiary reasons what the property's like, okay? It's also important to make a good record because if it is appealed, the courts will then look at the minutes of the Planning Commission or ZBA, and those minutes must be detailed. It's not like a council member meeting where you're just recording the motions, okay? You need to summarize in great depth what people say, okay? Because that's like the transcript of the trial, okay? I often, and if the village hasn't invested, I strongly urge them to invest in a tape recording system. That will assist whoever is taking the minutes to, in fact, be able to gather as much detail. Okay, if you're there at a meeting trying to take notes, It's hard to keep up with statements, but if you have a tape recording system, you can listen, transcribe or look at or summarize your minutes, go back and pick things up if you missed something. And so a recording system is a very important tool when you're dealing with zoning decisions, okay? What I want to do now is kind of look at the various roles of the municipal bodies that deal with zoning. First one I want to talk about is the village council. Village council has the legislative authority for the village. They're the ones that enact the zoning ordinance. And the zoning ordinance is the law in terms of property use and land use within the village, okay? It's the law, it has the force of law. It can be enforced. You can go to court and enforce that. There can be tickets issued, okay? They basically do that with the recommendations from the village planning commission. The village council controls the budgets. They decide how much training, for instance, are we going to give our appointed officials so they can make decisions properly. They're going to appoint planning commission members themselves and ZBA members. So the village council plays a key role in zoning because they kind of set the tone, if you will, of how zoning is going to be administered in the village. The planning commission, on the other hand, is again, it's an appointed body. It has primarily administrative functions. It develops and periodically reviews the village master plan. So it's kind of a plan for how you want to see the village developed over the next 10, 15, 20 years. And it's periodically reviewed and updated every 5 years as needed. You have the planning commission reviews and makes proposals for amendments to the zoning ordinance. They have to have public hearings in order to do that, to have the zoning ordinance amendment. And after the public hearing, they then summarize what was said at the public hearing and present that to the council, typically by just giving them the minutes, give the council the minutes from those public hearings. They also decide whether to approve site plans. This is the first thing to look at in your zoning ordinance. The site plan approval standards of your zoning ordinance, section 6.03.5. Okay? Those are what someone has to be able to establish as being met in order for the planning commission to approve a site plan. They determine whether to issue or to grant special use permits. Okay? Again, you're required by the statute to hold a public hearing. You must apply the standards of the zoning ordinance for special use permit approval. Okay? Again, standards in your ordinance for the general standards for special use permit approval, section 7.02.3. Okay? Those standards must be found to be met. And then depending on the specific use, if it's listed in Article 8 of your zoning ordinance, there are supplemental standards for those particular uses. Okay? And again, those standards and requirements must be met. If the applicant satisfies all of the standards for approval in the zoning ordinance, the planning commission is required by law to approve the special use permit. Okay? It's not a function of whether you like it or don't like it. It's a function of whether they meet the approval standards. And if you find by evidence at the public hearing that in fact they meet those standards, you are required by the Zoning Enabling Act to approve that special use permit. And we're going to talk about circumstances like that at the time being, okay? Again, planning commissions decide whether to approve planned unit developments, or what's commonly known as a PUD. Your zoning ordinance, the standards for PUD approval, section 8.12, capital I. Again, each one of these discretionary decisions is governed by standards that are contained in your zoning ordinance. You must always, when you're coming to a zoning meeting, bring your zoning ordinance. And if you don't have a copy of it, you need to get one. That's the Bible in terms of zoning regulations in the village. okay? ZBAs, okay? In a village, ZBAs can either be the council themselves, or it can be an independent body, and it's my understanding that the village has in fact appointed an independent ZBA, and the council itself does not act as.
No, that's not right.
The council does, the ZBA?
Council is the ZBA,
Oh, okay,
planning commission, DDA combination,
okay, so you are leading the, and where are all your council members?
everybody.
Okay, yeah. So again, that's kind of important to know. Let me take a few minutes to talk about that. When you're dealing with normal decisions that council makes, okay, whether to buy a snowplow, or whether to buy some kind of a truck, whether to,
My jacket's talking to me.
that's,
It's very cheerful.
it is, I really appreciate the sound, it's really nice. It's not annoying at all.
That's why I know it's.
You never want to do that in court. Never take your cell phone into the court.
Oh, I know.
Judges will, you'll get fined for that. And so I leave it as a habit, I leave them in the drawer. So like I said, the normal council meeting is you're making policy decisions. What kind of a sidewalk do we do? What kind of a paint do we put on a building? Okay, those are general issues that may have an impact. The public may decide, well, we don't think you need to buy a snow plow truck today, okay? And so they pack the room and they say, well, that's a bad idea, and the council is sensitive because they are elected officials to the will of the public, okay? When the council serves as the ZBA, you cannot wear your political hat, okay? You cannot make decisions based on the popularity of the particular decision, okay? You are required by law to apply the standards of the zoning ordinance. And so that often can be confusing or difficult for the elected village council because they're not used to setting aside the political considerations for decision making, okay? And so if you do and you make decisions based solely on political will, you're gonna get into legal trouble, okay? There's nothing I can do to stop that, okay? And so I guess I really want to emphasize the fact that political decisions, even though you're sitting as a ZBA, cannot be made based on political considerations, okay? So when you're looking at the ZBA, there are various kinds of cases that a ZBA can look at. They have the authority to make interpretations of the zoning ordinance. What does the zoning provision mean? And so what they have to look at is when you look at an interpretation, that is truly a legal issue, okay? Rules of statutory construction apply. You can only interpret a zoning ordinance provision if there's ambiguity. There has to be some ambiguity, various meanings of language, okay? If the language is clear, okay, you just can't change the meaning because you want to, okay? If the language in the ordinance is clear, that's the law, okay? You have to apply it as written. So only when you get to ambiguities, then you are allowed to interpret those kinds of things. Again, very legalistic in application, okay? The next kind of a decision that a ZBA make, they hear appeals. Say Scott makes a decision on a zoning, to issue a zoning permit, and somebody doesn't like that decision. They can appeal that administrative decision to the ZBA, okay? ZBA would then look at the circumstances, look at whether Scott was in his appropriate legal rights to issue the permit, whether the requirements of the zoning ordinance and stuff are met, and therefore appeal that, okay? You can then, the primary use of a ZBA is for variances, okay? There are two kinds of variances that a village can grant. There's a dimensional variance, which means that it's a variance from the dimensional requirements of the ordinance. side setbacks, the height of a building, something that has to do with a measure, okay, a measurement, okay? The minimum lot size, the square footage, something that's mathematically can compute, is in fact a dimensional variance. And again, the standards for a dimensional variance, 9.05 capital A. The other kind of use or variances that a village ZBA can grant is a use variance. A use variance has nothing to do with dimensions. Districts, zoning districts authorize certain named uses, specified uses. A use variance allows a use in a district that would not otherwise be allowed. That is very problematic, if you will, for especially a ZBA that's also the village council. Remember what a variance is, okay? What is a variance? A variance is legal permission to violate your zoning ordinance. Very simplest terms, that's all a variance is. It's legal permission to violate the ordinance. If the zoning ordinance says you have to have a 10-foot side yard setback before you can build a building, and someone is granted a 2-foot variance, they're now legally allowed to build within 8 feet of that property line. They're given legal permission to violate that 10-foot requirement, okay? Remember what has to go through when you have a zoning regulation. Planning Commission has to hold a public hearing, okay? Gather the input from the public as to what the appropriate regulation should be. It then is given to the council. The council then enacts it, makes a law, okay? A variance, by the stroke of a pen, undoes that entire process, okay? And so you have to be conscious of the limitations that you have when you're dealing with variances. A dimensional variance, I would say 90% of the time should be denied, okay? A dimensional variance is not something that should be given out like candy, okay? You only give a dimensional variance when in fact there's some unique characteristic of the land that basically says that you cannot comply with the zoning regulation. Classic example, if I've got a wetland, can't build in a wetland, and so the only building envelope that you might have pushes that into a setback, okay? So there's a physical characteristic of the property. If I've got a very small lot, and if I apply all of the setbacks on this substandard lot, I may have a building envelope that's 2 feet wide by 10 feet long, okay? You can't build on something like that, and because of the unique characteristics of this substandard lot, you can grant variances, okay? So, and you'll see some examples of most of the time when someone asks you for a variance, they're just asking for it because they want it, because it's easier, it's more convenient, okay? Those are not appropriate reasons to grant a variance. A use variance, okay? A use variance is not, and I repeat, is not a shorthand way of amending the zoning ordinance, okay? A use variance, 99.999% of the time, must be denied, okay? Everybody knows what a takings is, right? Unconstitutional taking of land, and because of a zoning regulation is so onerous or so restrictive that you have no economically viable use of your land. That's a takings, okay? A use variance properly applied is like a check valve, okay? So our ordinance regulation is so bad, so restrictive, that it's an economically viable or economically no use of the land. The law allows the granting of a use variance to allow some reasonable use of the land, okay? So you grant the use variance as opposed to paying money damages for the unconstitutional taking. That's the only proper use of a use variance. If someone wants to add a use to a district because that's what they want, it's not appropriate to grant a use variance. You amend the ordinance. You go through the public hearing process with the planning commission, and the council then adopts an amendment, okay? So there are ways to fix things, but you have to do it the proper way. Municipalities often get into trouble legally because they try to fit a square peg into a round hole. They're doing shortcuts for expediency to gain a policy objective, and they do it wrong. You're utilizing the wrong procedures. As a municipality, as a council, you can control zoning regulations in the village. So you can make changes as you want to, but you have to follow the right legal process. If you don't, you're going to come into legal problems because you've got a history of giving out variances like candy, and all of a sudden you want to hold the line on someone, okay? And they can say, well, look, we're similarly situated with all these people that have in fact been granted a variance. You're treating me unequally in violation of equal protection, okay? So you have to be sure that you're applying your ordinance in a fair and objective way, okay? Zoning administrator, very simple. Zoning administrator is nothing more than an employee, okay? They're under the supervision of the president or the council, or however they set up their personnel things. The job duties are typically formulated in the ordinance. They administer it, they enforce it, and do those kinds of things. And again, because the zoning administrator has the responsibility to administer the ordinance, sometimes there's going to be, again, ambiguities in the ordinance. What does this provision mean, okay? Zoning administrator has the authority to make that initial call. I think it means this. Someone disagrees with that administrative decision, they can appeal it to the ZBA, okay, just like the issuance of a permit, okay? What I wanted to talk about now is the process. The process of a zoning decision is probably more important than the decision itself, okay? Because if someone doesn't follow the right process, that's how the courts will go to strike down your decision. As the village attorney, I could care less what decision you make, okay? My role as the village attorney is to make sure you follow the correct procedure so that whatever decision you make, I can defend in court, okay? It's not my role as the attorney to tell you how to make the decision in terms of the merits. My job is to show you the proper procedures, make sure it's based on evidence that can be defended in court so that the decision is going to be a sound decision, okay? Conflicts of interest. The Planning Enabling Act requires that conflicts of interest be specified in the ordinance that creates the Planning Commission or in the Planning Commission rules of procedure or bylaws. The ZBA rules of procedure requirement for conflicts should also be included in their rules of procedure. I've given you some examples of conflicts of interest that relate to various things. If you look at subsection A and those examples of the conflicts of interest, where I talk about the child, grandchild, great-grandchild, and all that good stuff, I kind of got that out of the court rules, okay? There are court rules that mandate when a judge must not hear a case because of a conflict. The court rule uses the term the third degree of consanguinity. I just love that phrase, okay? Nobody knows what that means, and so then I just listed those relationships that constitute the third degree of consanguinity. So if I can say that more and more, I do that every time. And so again, I'm not going to spend a lot of time on conflicts of interest because that's pretty well spelled out in the thing. I want to spend more time on page 4 of the outline talking about your constitutional, your federal and state constitutional duty to be a fair and impartial decision maker. Like most communities, especially in northern Michigan, you have a coffee table where everybody sits around and solves the world's problems, okay? Could be at at Brothers, it could be, you maybe get together at the park, whatever. People know who you are, and they know that you're on the planning commission, or you're a council member, or whatever. And I'm just gonna pick on the big box store, let's say it's a Walmart, okay? And someone has a Walmart they wanna put into your community, okay? That's a big deal, okay? That's gonna impact your community. And some people are gonna be in favor of it, and some people are gonna be opposed to it, okay? But they know that you're on the planning commission. And they know that the zoning order says it's gonna be a special use permit. And so the planning commission is gonna have to decide whether to let Walmart come into our community. So what do? They sit you down at the coffee table, and they know that in fact you're on the planning commission. And so they bend your ear. They're saying, we think this is a bad idea because of this, 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 and this. Or they think it's a good idea because of this, 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 and this, okay? And so you have to be very careful, okay? As a planning commission member, you cannot make your decision based on popularity. You cannot make your decision based on your own personal thoughts. You must make your decision based on evidence presented at the public hearing and whether you find that the approval standards are met or not met. That's how you make your decision, whether Walmart's going to come in or not. Not whether it's going to create hundreds of jobs for the township or the village, not whether it's going to put out your downtown businesses out of business because the big box store is coming in, all right? Those are political considerations. Those are not zoning considerations. And that's why you have to talk about, well, so you're in the coffee table, and you say to people, sorry, I'm on the planning commission. This matter's been applied for, so it's going to be coming before the planning commission. I really can't discuss the merits of whether Walmart's a good idea or a bad idea at the coffee table. I'm sorry. I've got a constitutional duty to be a fair and impartial decision maker. But your opinions are important. So I would encourage you to come to the Planning Commission public hearing so that all of the Planning Commission members, not just me, can hear your opinions as to whether you think it's a good idea or a bad idea. Invite them into the process. That's how you deflect that, okay? As opposed to saying, I can't talk to you, okay? Invite them in, so tell them when the public hearing, if it's been scheduled, if it hasn't been scheduled, make sure they know when it is, so they can then participate in the process, okay? As opposed to trying to do an extrajudicial or ex parte communication with you. That can get you into trouble. And that's often difficult, again, in a small community, to understand that you have a constitutional duty to be fair and impartial, not only to the members of the public, but also to the applicant, okay? That you're making these decisions. Now I want to talk about the actual public hearing itself. You're going to have a chairperson that's going to be chairing the public hearing. It's really important for this individual to have control of the meeting. All comments need to be made to the chairperson. You don't want people in the back of the room getting into arguments amongst themselves because that just turns your meeting into chaos, okay? There has to be order. And generally when you're looking at a public hearing, you identify the documents, any piece of paper that the Planning Commission or the ZBA is going to look at and utilize to make its decision. It needs to be identified as an exhibit, okay? Number one exhibit, zoning ordinance. Number two is probably going to be the application, or whatever app that they're looking at. Photographs, site plans. You could have letters from the community that are sent in, okay? You could have an appraisal, okay? Property appraisal. What's going to be the impact of the proposed development on adjacent property owners, okay? So those kinds of things are documents that you identify. Lots of boards have time restraints, like 3 minutes, okay? That generally does not apply to the applicant. Remember, the applicant has the burden of proof. must prove that the approval standards are met, okay? So it's very, again, going back to my trial analogy. As a prosecutor, I had to prove the state's case, okay, beyond a reasonable doubt. So I would present my evidence, my witnesses, my exhibits. The defense would then have an opportunity to present its case. Then, because the prosecutor carries the burden of proof, the trial then allows the prosecutor what they call rebuttal, okay, to rebut the information presented by the defense. Very similar to a public hearing process. Applicant goes first, okay, makes his or her presentation as to why the approval standards are met, as opposed to how good the development's going to be, okay? Members of the public, typically speaking in favor of the application, should then be given an opportunity. When you have those people that are opposition, they should then be given an opportunity. If you've got a spokesperson that can, lots of times you get an organized group and they have an attorney, and you give them the time for their presentation as to why the approval standards are not met. And then you give the applicant rebuttal time, just like in a trial. So they have the ability, because there's going to be issues raised by the public in opposition. So you should give the applicant, in fairness, an opportunity to explain, answer those questions or make those explanations. And you do that at the end, as opposed to having them debate back and forth amongst themselves during the course of your public hearing, because then you lose control of your public hearing, and that's why you have police often come to controversial things. Not necessarily for, you've got your zoning administrator here who's going to be there with his badge on. But lots of times in a rural township, you have a sheriff's deputy sitting in the back of the room, okay? Just the mere presence of law enforcement at a controversial public hearing keeps everything in check, okay? And so that's not an uncommon process. So you go through this process of gathering the information. Ultimately, you then are going to close the public hearing. The public hearing, that's where your evidence is gathered, okay? Now you have to begin your deliberations. It's like the jury going into the room to deliberate. You look at the standards of approval. That's like the jury instruction. Here's the law. The law says you have to meet these approval standards. Then you look at the evidence presented, okay? And you make findings of fact as to whether those approval standards are met or not met, okay? During your deliberation process, you may have questions, both of the applicant and maybe members of the public. You can ask those questions. You can receive that information without opening the public hearing again, okay? There are times, however, that you're going to want additional information on a particular topic. It could be property values or whatever, okay? It could be on runoff. And so you can adjourn the public hearing to a specific time, date, and place and gather additional information. Have people bring you more information on a particular issue. And so if you hold the public hearing open for a topic, then everybody should have an opportunity, both for and against, to present information on that very limited option. So when you come back a month later, you're gathering additional information on that limited topic as opposed to hearing everything over again, okay? There are going to be times that you're going to gather the information at the public hearing, and frankly, attorneys are notorious for this. They come in with a packet of information at the meeting that's an inch thick, okay? You haven't had an opportunity to review that. You haven't had an opportunity to really study it, yet they want you to make a decision. You can't do that, okay? You, in fairness to the applicant or the public or whoever presented you the information, you need to read it, okay? You need to at least consider it. And so oftentimes deliberations are then postponed or adjourned, again, to a specific time, date, and place, so that you can make your findings of fact at a later time, okay? So you can give due consideration of all the materials that are presented as opposed to basically ignoring it and making your decision, okay? What I want to do now is to go over some specifics, okay? And what I've done is I've developed a couple of what I call case studies. And I'm going to start with the Planning Commission, since we got more Planning Commission members here. If you look at this document, It's called Planning Commission Training Seminar Statement of Facts, okay? It's a 2-page document. It's called Read First in the top right-hand corner? Yeah, right-hand corner. Okay? Everybody had a chance to read that? Okay? Everybody find it? Since you've all had a chance to read it, by a show of hands, how many, and what this is intended to do, the summary of facts is intended to really kind of summarize the information that you would be getting at the public hearing, okay? And so by a show of hands, how many people are generally favorable, would have a tendency to grant a special use permit for this bed and breakfast? Anybody? Okay? How many people would be inclined to say no to it? Okay? One. Jude, let me pick. What's that?
It's dimensional.
Okay? Basically, typically in a seminar, I get half the room raises their hand in favor, half the hand raises it in opposition. And then I tell them, you're both wrong.
No, I'm not gonna, because I haven't read it yet.
That's right. You really are both wrong. People that say they grant it and those people that say that they wouldn't grant it are both wrong. Because you're making a decision based on your gut. Okay? You're looking at, does it feel right? Okay? That's not how you make zoning decisions. You make zoning decisions based on the standards. You know, and typically I like to hide the next document because you haven't really talked about what the standards are for the approval of a special use permit. Okay? I've given you these things in this read second document. Okay? And this is the same process for ZBAs as well, but here are the special use approval standards, 1 through 5. Okay? So these are the standards you have to apply based on the information in the first document, the public hearing record. Okay? The third document I want you to look at is how these two things are melded together. Okay? This is what I call my decision and order form. Okay? Yep, the read third document, yep. If you look at this, let me kind of take some time to go through this. First page, you kind of summarize what the application's all about, then you get into your general findings of fact. And again, you're trying to document the situation, putting into words what everybody knows. Okay, all the planning commission members have gone to the property prior to the public hearing. You know what it's like. You know all the ins and outs of it. Okay, remember who your audience is. It's not your fellow commissioners. You're doing this for a judge. Okay, a judge who has never seen this property, never will. Okay, so you need to describe in words what the general nature of this property is all about. Okay? Applicant desires to operate a bed and breakfast. That's a fact, based on the application. Okay, that's your exhibit. Planning Commission finds that the property is zoned R1 under the zoning ordinance. What's your evidence? The zoning ordinance. Okay, the zoning map. Bed and breakfast is a permitted use in the R1 district. Again, obvious thing that everybody knows. Okay? It's so obvious you wouldn't necessarily think about documenting it, okay? But again, Judge in Lansing doesn't know that, okay? That's why you have to put it into a finding, because you're documenting this for a court review, potentially, okay? Finds that the applicant's house is a 2-story structure. Well, we all know that. We went and looked at it, okay? There may be a picture of it. Judge in Lansing doesn't know that, okay? That's why you need to be, you got to get down to the nitty-gritty details to be able to show that in fact what you have. And so you go through the general findings. Turn to page 2. Now we're getting into the specific findings. You see that the first standard, whether the special use permit will be designed, constructed, and operated. If you go to the read second document, okay? you'll see that that's the first standard. All I did was I repeated the standard, okay? Once I have the standard, then I looked at what the findings are. Planning Commission finds that the proposed bed and breakfast will be operated within the applicant's existing house. That's a fact, based on the application, okay? Based on what the applicant told you at the public hearing. Planning Commission finds that the residential homes in the area are constructed using an older style of architecture. Again, that's explained, okay, in the public hearing. Planning Commission finds that the applicant's house is also constructed using the older style architecture and is not significantly different in architectural appearance. So what that's saying is that the proposed structure is blending into the neighborhood. It's not going to be an eyesore within the neighborhood, okay? Finds that the proposed bed and breakfast will not require any exterior alterations, okay? Planning Commission therefore finds that the proposed bed and breakfast will be designed, constructed, operated, and maintained so as to be harmonious. It's blending in, okay, based on those objective facts. So they found that the first standard was met, okay, because it's the same type of architectural style. It's not going to be different than the general characteristics of the neighborhood, okay? Number 2, whether the special use will be adequately served by essential facilities and services, such as highway, streets, police, fire, blah, blah, blah. Planning Commission finds that the applicant's house is located on a public street, is connected to the village water and sewer system, and is within the jurisdiction of the village police department. Again, objective facts, okay, that relate to the standards. Planning Commission finds that the applicants are currently served by a commercial garbage removal system with weekly pickups. Again, talking about refuse disposal. That's a standard of your ordinance. We've met that, okay? We have regular garbage things. Proposed bed and breakfast will intended to cover a dumpster in the backyard, okay, and will be screened from view. Planning Commission finds that the drainage is not an issue since any rainwater will be naturally absorbed or will run into the village stormwater drains. Again, relating to the standard for approval. See how that relates to the standards? Planning Commission finds that since the proposed bed and breakfast will not create new residents in the village, there will be no impact on local school districts. We're not going to be adding kids to the school district because of this bed and breakfast, okay? Planning Commission therefore finds that the proposed bed and breakfast will be adequately served by essential facilities and services such as highway, streets, police and fire, drainage, refuse disposal, water and sewer facilities and schools. So we have objective facts that were presented in the Read First document, okay, that shows how that standard was met. Everybody sees how that was done? Okay? Number 3. Whether the special use will not create excessive additional requirements at public cost for such facilities and services, the Planning Commission finds for at least the last 20 years, the applicants have owned the property and have raised their 9 children. Lots of people. They have 9 children. Okay? Before the children graduated from school, 11 people resided in the house. Okay? That was their normal family. Okay? Obviously, this bed and breakfast is a larger house. That was the reason for that kind of a thought. Okay? During this time, the Planning Commission finds that the applicant's property was adequately served by public facilities and services, such as streets, water, sewer, police, and garbage removal. So while they had 11 people in their house, okay, their normal family, everything operated properly. Sewers were taken care of, no problems with runoff and those kinds of things. Planning Commission finds that only 4 of the house's 6 bedrooms will be used in connection with the proposed bed and breakfast. So again, they're proposing only to use, because some of the rooms, they want to keep the kids when they come home, and they're going to be living in one, okay? So they're not opening up the entire house, they're only limiting it to 4 bedrooms, okay? Planning Commission finds that even with an average of 3 persons per bedroom, the maximum number of guests would be 12 on any given day. Therefore, including the applicants, the maximum number of people occupying the house on a given day would be 14. Again, objective facts, okay? Planning Commission finds that the proposed bed and breakfast will not be fully occupied every day of the year, but rather will vary depending on the season of the year. Planning Commission finds that although the village sewer system in the area of the applicant's property is one of the oldest in the village, The planning commission finds that the system has historically provided adequate sewer service to the house when occupied full-time by 11 people. So when the kids were there, the sewer system was fine, okay? They're not gonna have that many more people on a regular basis. It's gonna be periodic, maximum maybe of 14. You're gonna have sometimes the bed and breakfast isn't gonna be fully occupied. And so on average, what the planning commission is saying, you're gonna look at it, probably no more than 11 that's been historically there. Sewer's been adequate, hasn't it? We haven't had any problems, right? Even though the neighborhood's screaming bloody murder about this, okay? The planning commission, G, to find that the proposed backward will not create excessive additional requirements, okay? 4, whether the special use will not cause traffic congestion, conflict of movement of greater proportion than that normally prevailing for the use of the particular zoning district. Planning commission finds that since age 16, the applicant's children have driven their own motor vehicles, parked them next to the applicant's garage, and backed them out onto the street. Again, typical family scenario, okay? Because of the children's ages, the planning commission finds that the number of children driving during the same period of time was 2 or 3. Again, depending, some are going to be less than 16, some are going to be more, okay? Planning commission finds that during the time the applicant's children were driving and backing onto the street, no motor vehicle accidents were reported. So again, we're showing a history, objectively, that even though we're going to have bed and breakfast patrons, historically they've had motor vehicles in and out of this house for a long time, okay? And there's been no problems with traffic congestion and motor vehicle accidents, okay? Planning commission finds that since only 4 bedrooms will be used in connection with the proposed bed and breakfast, the maximum number of guest vehicles will be 4 or 5. This number represents an increase of only 2 cars above the historic traffic generated on the property. Planning commission finds, however, finds that the proposed bed and breakfast will not be fully occupied, finds that the increase in 2 vehicles on a part-time basis is not a significant increase. Planning commission finds that although the neighbors have concerns over traffic safety, they have presented no evidence to support those concerns, especially in light of the historic record of not having traffic in. See, when you're dealing with things, people will give you horror stories of what they think is going to happen. But is that objective evidence? Okay? The example I often give, people can give you opinions on everything, okay? I can give you an opinion, okay, on brain surgery, right? Would you want to rely on my opinions when it relates to brain surgery? So just because someone has an opinion, you have to decide whether that opinion is worthy of weight, of consideration. That's a decision that is often made in the courtroom. Judges all the time are called upon to decide who caused the accident, okay? If you've got an intersection that's governed by a traffic light, and you have a collision in this particular intersection, there's going to be some witnesses that will testify that the light was red, okay? There are going to be some witnesses that will testify the light was green. Judge wasn't there, okay? Judge has no idea what color that light was at the time of the accident. So how does the judge make that kind of a decision? You have to look at what piece of information is more credible. Where were these witnesses standing? Okay? Were they more observant? Were any of the witnesses colorblind? Okay? Did any of the witnesses have a reason to lie? Okay? So by looking at the credibility of the information that you've presented, the judge can then make a decision. I believe this information more than that information. I'll give you an example. You will oftentimes find people stand up at a public hearing and they'll say, this proposed development is going to make my property values plummet. Okay? All the time I hear that. And they have a right to give you that opinion. Okay? I have a right to give you an opinion on brain surgery. Okay? So when you're looking at information from a John Q. Citizen, it says, my property values are going to be reduced, and the applicant then comes in with a market study, okay, showing property values and how they're impacted on similarly situated neighboring properties to a use very similar to what's being proposed, and that market study shows no decrease in property values, okay? What piece of information are you going to find more reliable? See that? You've got an actual study being done as opposed to someone's personal opinion, okay? And you have the right as a planning commission member to evaluate the information. So just because someone gives you an opinion, you're not required to accept that, okay?
Does
Yeah.
does the planning commission have the opportunity to require that study to be done?
It can if it wants to, if it finds that is important, okay? But I wouldn't draw that up on every circumstance, depends on what other information you have. You might have two competing pieces of studies. That's true. You get experts in the courtroom all the time saying opposite things. Okay, again, the judge is then required to decide which one they want to believe, okay? So you're given that discretion. It's kind of an interesting thing. Whatever you find, as long as you've got evidence to support that decision, the courts will uphold it. Courts will bend over backwards to support a local decision that's properly made using the proper procedures and proper evidence, okay? Courts don't want to sit as a super zoning board, okay? They don't want to make those local decisions. They just want to make sure that you follow the rules, okay? And again, the same process goes for all of these things. So when you actually look at the approval standards for the planning commission, and you then critically apply the information presented at the public hearing, all of the standards are met, okay? And if all of the standards are met, what are you required to do? You're required to approve it. So even though people that have had their hands up saying they didn't want to approve this, okay? You see how that process works now, okay? Another point I want to make and if you look at my facts in the read first document, and I did this for a reason. The neighbors in opposition. 50 neighbors appeared at the public hearing, okay? What is typical when you're dealing with local decisions? When someone wants something to happen or they do not want something to happen, what do they generally do? They pack the room, okay? They put forth political pressure, okay? Wanting you to say one thing or the other, all right? That's not how zoning decisions are made. Zoning decisions are not a popularity contest, okay? That's why I put in what I call the angry mob, okay? It's the angry mob syndrome, okay? Just because you have more people at the public hearing and these angry mob people are more boisterous than everybody else doesn't mean that you side with them. Again, they have to present evidence, okay, that shows an approval standard is not met. And frankly, they have an easier task. Because if they can convince you that one of the approval standards are not met, you can deny. In order to approve a special use permit or a variance, you must find that all of the approval standards are met. So if you find that one is not met, you may find all three of them are met, one's not, you deny. Okay? So the opposition has it easier, because they only have to prove one is not met in order to deny approval. Okay? So I did the same kind of a scenario with the variance as well. If there's any questions, we can go over those. Oh, one thing I want to show you that I didn't talk about yet. Dealing with planning commissions, this is what I call, it's like the decision in one form, but it's blank. Okay? If you look at the second page, you see how this is done. You have the same standards, and it says the planning commission finds that, the planning commission finds that, okay? This is intended to be a worksheet, okay, that should go out with the package, the packet. And so what you're doing is, when you're looking over the materials, getting ready for your meeting, it focuses your attention on the approval standards, as opposed to looking at whether it's a good idea or a bad idea. you can then jot down your notes. Well, I think the standard's met.